The acting Chief Justice Philomena Mwilu may have received a temporary reprieve after a court-issued stay orders against the enforcement of a ruling barring her from office for a period of time. But questions on her integrity continue to injure Mwilu's chances of assuming the coveted Chief Justice position. Despite this, there has been an uproar on the ruling, with some in the legal fraternity terming it as a constitutional coup. Zainab Ismail interrogates the impact of the ruling, the woes surrounding DCJ Mwilu, and what it portends for the judiciary.
Deputy Chief Justice Philomena Mwilu might breathe a sigh of relief for the next 10 days, but a dark cloud still hangs over her head at the helm of the judiciary. Justice Patrick Otieno on Friday threw the judiciary into disarray temporarily after issuing orders restraining Lady Justice Mwilu from occupying her office and discharging her duties as acting Chief Justice and as a member of the Judicial Service Commission. An order that was then temporarily lifted on Monday for a period of 11 days, pending an inter-partes hearing at the Meru High Court.
I think that is what you'd consider as a constitutional coup, properly so-called. I think an explanation needs to be given by the judiciary. It's not enough to say it was an ex parte order.
Throwing in more confusion, the ruling also overlooked the process outlined in the Constitution for the removal of a judge.
You have to petition the Judicial Service Commission. The Judicial Service Commission will form a committee to interrogate those claims on the face of it, if they make sense. They'll then write the judge, asking the judge to respond to those allegations. And if they feel that the grounds are substantial, then they would recommend the president to establish a tribunal. Then the president would establish a tribunal. The tribunal will now do the removal hearing, or the removal proceedings. If the tribunal is satisfied that those grounds have been proven, then the judge will stand removed.
Justice Mwilu had on Monday filed an urgent application seeking to suspend the decision. In her petition, Mwilu said the petitioner obtained what she termed as drastic and far-reaching orders by failing to disclose some facts to the presiding judge intended to cause embarrassment to the court. But as Mwilu's woes continues to multiply, the judiciary has been left in a state of limbo as Lady Justice Philomena Mwilu fights to clear her name.
Already, 2 judges have exited. The Chief Justice exited. Justice Jackton Boma Ojwang retired. If you remove or you suspend DCJ Mwilu, then now the threshold quorum at the Supreme Court falls to 4. The quorum by the law is that judges must be at least 5 on the bench. To constitute a full bench to hear substantive matter application, such as the pending Supreme Court advisories, whether the BBI referendum should proceed or not, you need a full bench of at least 5. It means the Supreme Court is effectively crippled.
The case will be heard on the 12th of February. Zainab Ismail, NTV.